All right, good afternoon, everyone. Good afternoon. It is great to see you all. My name is Roger Fairfax, and I'm the Dean of the American University Washington College of Law. And on behalf of President Sylvia Burwell and the entire American University, I want to welcome you to Advancing Diversity in College Admissions, What Comes Next. And as Dean of WCL, I am proud to participate in this university wide discussion. Our motto at WCL is we champion what matters, and this topic certainly does matter. And I'm thrilled to see all of you here in the room for this important discussion. And I know we have others on live stream as well. So thank you for tuning in. So this past spring, today's panelists and I convened along with the American University General Counsel Trevina Bird to explore efforts in higher education to enroll student populations that reflect America's diversity and the world's diversity. And our AU experts discussed the issue's history and legal precedents and upcoming developments at that time that could affect admissions processes throughout the United States and the ways that universities could continue to advance diversity, equity, and inclusion. Now, of course, since that last convening, the United States Supreme Court ruled in Students for Fair Admissions, SFFA, versus the University of North Carolina and SFFA versus Harvard, that the admissions plans, as a majority of the court perceived them, being utilized by the University of North Carolina and Harvard College violated the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964, respectively. Now, today, those same American University experts you will soon meet are joining us to examine the work following the Supreme Court's ruling, the challenges presented by the decision, and the path forward to continue pursuing diversity in higher education student populations. Now, I've been actively engaged in these issues myself in a number of capacities. I have a long time affiliation with the NAACP Legal Defense Fund. I've been involved with the Harvard University governing boards, which obviously defended the litigation related to Harvard College. I serve on the board of directors of the Lawyers Committee for Civil Rights Under Law, which made argument as a friend of the court in the University of North Carolina case. And I've worked in the college access space for over 30 years, primarily with at-risk kids right here in the District of Columbia. And most recently, President Burwell asked me to work with the General Counsel and with the undergraduate and graduate deans to lead a university-wide admissions working group in the wake of the Supreme Court ruling. But today, I am merely here as a moderator and a facilitator. And my job is to facilitate a conversation with two true experts, American University's own Professor Sarah Clark Kaplan and Professor Leah Epperson. So I will introduce them both, and then we're going to delve into discussion of our topic, advancing diversity in college admissions, what comes next. So, Professor Sarah Clark Kaplan is the Executive Director of American University's Anti-Racist Research and Policy Center, ARPC, and an Associate Professor in the Departments of Literature and Critical Race, Gender, and Culture Studies. Prior to joining the faculty at AU, Dr. Kaplan was an Associate Professor of Ethnic Studies and Critical Gender Studies at the University of California, San Diego, where she was Director of the Critical Gender Studies program and also the co-founder and associate director of the Black Studies Project, a cross-campus research collaboratory dedicated to shaping the field of African American and Black diaspora studies for the 21st century. A scholar of Black and women of color feminisms, Black literary and cultural studies, and reproductive politics, she is the author of The Black Reproductive, Unfree Labor and Insurgent Motherhood, and her work has also appeared in leading journals. Professor Kaplan is currently working on two intersecting projects, a contemporary examination of the race and gendered politics of reproductive carcerality, and a literary historical study of Black feminist geographies of chatteldom. She's a longtime social justice advocate with a special interest in decarceration, reproductive justice, and welfare rights. And Professor Kaplan has worked on campaigns and projects with a variety of external organizations. As a member of the first PhD cohort admitted to the University of California after the passage of Proposition 209, Dr. Kaplan has been engaged in analysis and advocacy around racial justice in higher education for over 20 years. Please join me in welcoming Dr. Sarah Clark Kaplan. To her right is Professor Leah Epperson. Professor Epperson is a national expert in constitutional law, civil rights, and education policy. Published in leading journals, her scholarship centers on the constitutional dialogue between federal courts and the political branches and its implications for educational equity. From 2014 to 2018, Professor Epperson served as Dean Epperson, Senior Associate Dean for Faculty and Academic Affairs at WCL. And she has taught and lectured and conducted research at universities around the world and has appeared on news outlets including CNN, NBC News, and C-SPAN. Prior to becoming a law professor, Professor Epperson directed the Education Law and Policy Group of the NAACP Legal Defense and Educational Fund, LDF, one of the nation's most prestigious civil rights law firms. While at LDF, she litigated in federal and state courts, advocated for federal administrative and legislative reforms, and co-authored multiple amicus briefs to the United States Supreme Court. Earlier in her career, Professor Epperson was a law clerk to the Honorable Timothy K. Lewis of the U.S. Court of Appeals for the Third Circuit and was a lawyer with Morrison and Foerster in Palo Alto, California. She attended Harvard College and Stanford Law School, where she was an editor of the Stanford Law Review. Please join me in welcoming Professor Leah Epperson. All right, so we are fortunate to have two esteemed scholars and experts with us for today's conversation. And so I am going to jump right in, and I'll start with Professor Epperson. And what I want to do is ask you to break down the decision of the court in the University of North Carolina and Harvard cases. And specifically, what does the decision mean? What does it not mean? And that's also very important. What precedent does it set? And what does it mean for other models of promoting diversity within the student body, such as recruitment and retention and pipeline and outreach work? So if I can ask you to answer that multifaceted, multi-part loaded question.
I counted 5 parts. I hope I remember them. Good afternoon, everyone. So I'm happy to start. Let's see if I can go to part 1 of the 5-part question, which is really what are the decisions of the recent Supreme Court cases. And I think I will start with just a quick summary of what the cases were about so we can reach that decision. And so these were 2 cases that reached the United States Supreme Court that examined the legality of race-conscious affirmative action policies for admission. One was the public university, University of North Carolina, part of the state of North Carolina. One was a private university, Harvard University. So 2 noteworthy things about the cases coming to the court. We have a history, more than 40 years, of Supreme Court decisions around the constitutionality of using race-conscious admissions policies for public colleges and universities. And so those decisions date back to the late 1970s. With the University of California, with University of Texas, with University of Michigan. And each time the question is whether a public college or university's consideration of race as one of several factors in a holistic admissions process is comports with the Constitution or is in violation of the Equal Protection Clause of the 14th Amendment of the Constitution. And so in all of the precedent, the Supreme Court has consistently held that race can be one of several factors, not the determinative factor, not a quota, one of several factors in a holistic admissions process, and that it can be done because the court has prior to this decision held that the benefits that flow, the educational benefits that flow from having a diverse student body, are compelling. And so one way of achieving that compelling interest is to use a holistic admissions process. So that's kind of what led us to the UNC case. And it's also worth noting that what the court looked at in that case was what one would call a very high level of judicial scrutiny, and that's because it was looking at race. In our system, a consideration of race triggers what the court would call strict scrutiny, the highest level of scrutiny. So a policy that looks at, whether you're the first in your family to go to college, whether, you get a thumb on the scale for being a veteran, whether the college may be seeking geographic diversity, none of those things would trigger heightened scrutiny, but race does. So that is why, for those who wonder, well, why don't we look at wealth in this way, it doesn't trigger that heightened scrutiny. Harvard comes to the Supreme Court as the very first case that is a private university where their admissions policy is being considered. And so all of the cases prior to this one were public, again, looking at the Equal Protection Clause. The Harvard policy was being considered under Title VI of the 1964 Civil Rights Act, which prohibits any entity that receives federal funding from discriminating on the basis of race. So in this decision, the court was looking at, as like the legal angle, Title VI for Harvard, Equal Protection Clause of the 14th Amendment of the Constitution for UNC. And what is noteworthy is that in this case in 2023, they did completely upend 40 years of precedent. They have overturned the admissions policies at both Harvard and UNC. And they did so on one could say, sort of looked at a few things. One was the court determined that while the goals of diversity are, in their words, certainly commendable, it was a bit of a discussion almost of institutional competence, and the court looked at the policies and said, how do we measure that this is actually achieving this goal of diversity, this educational benefit of diversity? The court also looked at the policies and said, we do not want to have policies and practices that are about racial stereotyping. Now, you may have noted that Dean Fairfax said, as the majority in the court examined these policies, they see them as not comporting with prior goals. Just to be clear, every lower court decision in each of these cases outlined in great detail the admissions policies. So for Harvard University, race was not a determinative factor. It was one of 100 factors in their admissions policy. And this is at a university that for 85% of its history, 400 years, systematically excluded applicants of color. UNC, oldest public university in the country, founded in 1789 to educate the children of enslavers, only opened its doors to black students after 150 years, and a federal court order required them to do so. And in their policy, they used race as one of 40 factors. So for the universities that employed these policies, they were operating under what they believed to be, they were following precedent as best they knew how. And so the reason why these decisions garnered so much attention is that they followed policies that were similar to the ones that were upheld by the court 20 years ago in Grutter, as well as in the University of Texas case, UT versus Fisher. But again, the court articulated that the majority did not see how to measure this commendable goal of diversity, that the one thing they needed to be sure was to not have policies that would racially stereotype. And so then what does this mean? What are we left with? We are left with a decision in which the majority has, again, it is an upending of precedent. It is, for many people, I would commend the lengthy and very detailed dissenting opinion of Justice Ketanji Brown Jackson, where she goes through the history of these pieces of the Constitution and the Civil Rights Act, and really kind of traces the trajectory of how race has been considered by the court and what the role is of each of these. And she begins her decision by essentially saying that the majority opinion defies 45 years of history, logic, law, precedent, and justice. That said, It's also worth noting that Chief Justice Roberts, in his majority opinion, does make a distinction between what the court considers to be an admissions decision based on based on a sort of check the box, if you will, of one's racial status, and the ability to still consider an applicant's experiences of race in an admissions process. And so Roberts makes clear that nothing in the opinion prohibits a college or university's ability to consider how an applicant's race has impacted their life experience, their place in the world, their views of where they will go at a college or university. And the court also made clear that universities should be free to follow their mission. So those two pieces are actually quite important, I think, when we're talking about what the decision means for colleges and universities and for admissions processes in particular. The court was clear, and not just like a sort of rant and a dissenting opinion, but the majority of court was very clear that universities are free to follow their missions, which quite frankly for many, if not most, colleges and universities in 2023 includes a mission of ensuring that these pathways to opportunity are open and accessible to all people, including and especially those who have historically been excluded, and that colleges and universities are free to continue to consider one's racialized experiences as an applicant when they are applying to colleges and universities. When Dean Fairfax asks what the opinions do not say, so that's a little bit about what they held, I think it's important to note that it is specifically about college and university admissions processes. So there is nothing in the opinion that is about things that a college and university may do outside of admissions. It's not an opinion that touches or discusses scholarship programs. It doesn't discuss anything around overall diversity work that a university may do, DEI goals. It doesn't say anything about recruitment or retention or pipeline or partnerships. None of that is a part of this decision, nor is the decision touching in any way on employment. So I would just clarify that, because I think often what happens with major Supreme Court decisions and decisions that people see as overturning precedent or going against the grain or just highly controversial, there is a tendency to lead with fear rather than facts. And I speak about this also even in my experience 20 years ago with the Supreme Court's decision in Grutter. And that's when I was leading a lot of work on this and working with colleges and universities in the wake of a Supreme Court decision when there were general counsels saying, what do we do now? And it is important to hew to the letter of the law and to ensure that colleges and universities remain both steadfast in their mission and also very clearly making sure that they are in compliance. But part of that assurance of compliance is that every public university and every university that receives federal funding under Title VI, which is almost all of them, financial aid and whatnot, is those very laws that the majority used to strike down those existing admissions policies are also still in place and quite frankly founded to really provide the backbone for the moral and legal imperative that educational institutions have to ensure that those pathways to opportunity are open, that there is a recognition of a past that might have closed doors, and Title VI and the 14th Amendment are there to ensure that there is not a replication of that. So I think in 2023, that's the work that colleges and universities are asked to do, to make sure that they are still fulfilling that promise while sort of carrying out what the court has asked them to do. Did I get all five?
That you got all five.
Okay.
You got a sixth in there. That was great. Great job, Professor Epperson. So, well, thank you for that legal analysis. And I want to turn to Professor Kaplan to ask her to please shed some light on the socio-political implications of some of these issues. Certainly, there are the strategies that Professor Epperson talked about that are outside the scope of the opinion, like pipeline and recruitment work and retention work. So they have survived constitutional scrutiny for now. But what are the drawbacks and who gets left out when there's a focus on those? And then if you could also think about how the case does or does not reflect the contemporary material realities of race. and class and education in the United States, and what the implications are for broader racial politics. I think that was probably 7 or 8 questions.
Let me see. I think I got 5.
5.
Also, very nice. Okay, and I'm going to take the huge risk of taking these out of order, and I'm actually going to do this and then this. And I just have to confess, though I don't want to embarrass you, I'm always so excited for this because I get to talk about things that I'm passionate about, and then I sit next to Professor Epperson and I think, oh wait, this is just something I'm passionate about. This is something that Professor Epperson is an absolute national expert on. So I want to just say how lucky we all are to be able to have this conversation. Every time that I hear you break it down, I'm sitting here scribbling notes to myself for our next project and the next things I'll say. It's incredibly helpful for all of us to have this. And now I'm going to actually take these questions backwards. And I want to start with the question of what did the decision in these cases combined reflect or not reflect? And here is a caveat. Last time that we spoke, though, for those of you who were there, it may not have seemed like I was particularly holding my tongue or trying to be tactful, but in fact, for those of you who know me, you might know that in fact I was. And that, one of the key moments when a decision like this has not happened is I think that we have an important role as scholars who are affiliated with the university, not to speak in ways that overcommit us or speak too heavily about what has not happened. We're at a different moment now. And so I think that in order to make my largest case, which is that this struggle is actually not over, but is moving to a really new stage in thinking about what we have to do about educational access and equity, I want to really give a little bit more pointed of a critique of the case that was laid out sociopolitically and the decision that was made. I can't offer the kind of incisive legal critique that Professor Epperson has, but I can make this clear. So I think that turning back to Justice Ketanji Jackson's decision gives us a very clear starting point when she points out, as she does elsewhere, that the decision of the court in the end relied on many things, but none of them were the actual facts of the case. So what we see in this decision is a really clear set of ideas about how race works and how race works in college admissions and on college campuses that do not line up with scholarship in the field of race or scholarship in the field of race and education. And where I want to start with this is by thinking about, for a moment, how these cases showed up in the court. So as many of you know, these cases were brought forth by Students for Fair Admissions, right, which is an organization that, contrary to popular belief, or really maybe we all know this by now, is not a grassroots organization of students and folks committed to equal access to education who want to make sure that they're getting a fair shake. It is an entity that is largely funded by a single individual, Edward Blum, and was organized entirely with the goal of overturning affirmative action as it currently exists. Now, for those of you who may have your own stance on affirmative action or race-conscious admissions, one might say, well, if this is, the horse he wants to ride, that's absolutely fine. The windmill he wants to tilt at, he's committed to fair education and colorblind admissions, that's fine. But I want us to also put Edward Blum in a context. Edward Blum is the same person who basically provided most of the impetus and funding for Shelby versus Holder, the Supreme Court case that overturned the portion of the Voting Rights Act that made it possible to avoid the kinds of intense gerrymandering and disenfranchisement of Black voters that we are now seeing throughout the South. So when we understand SFFA's mission within the context of a larger racial political project, we have to understand it within a trajectory of work to undermine the civil rights, the primary civil rights gains of the 1950s and 60s. We see these kinds of attacks on the Voting Rights Act. We see these kinds of attacks on affirmative action, which came out right after the Civil Rights Act. Right? We see the ways in which the direct goal of Edward Blum has been, and we can see in the kind of work he's doing now, has been to kind of slowly chip away at civil rights legislation that has ensured access and equity in virtually every area, at the voting polls, in education, and we're increasingly now seeing in places of employment and in K through 12 education. So I want to put this in this context because this is how we understand both of these cases, but particularly the misconceptions about race that underlay the Harvard decision. So what makes the Harvard decision unique is that it was the first decision that featured plaintiffs who were not white. This was not Edward Bloom's first bite at this apple. Edward Bloom was also, right, SFFA, was also the organizer of the Fisher case versus University of Texas, which, while it made some progress in eroding this sense of compelling interest, and in eroding race-conscious admissions capacities and, sort of shifting what counts, what doesn't count, how much can it count, it did not really change very much. And, there's a kind of tale that those who have been doing research in this area for years tell that Edward Bloom was documented as going to a dinner party after the Fisher decision and saying, somebody needs to get me an Asian plaintiff. So this was a very conscious choice in turning to Asian Americans. So why Asian Americans? This is where racial misconceptions become crucial. Let me ask a question. How many of you have heard of the model minority myth? Okay. So the model minority myth, as we know, is often thought of as a positive racial stereotype, right? It's thought of as this idea that Asian Americans who come to the United States or are born in the United States come from cultural backgrounds that prize education, that are committed to racial uplift and to inclusion and assimilation, and that they work hard, study hard, achieve well in school, don't make trouble, and contribute to society. They're good citizens, they work hard, and they do well. So the model minority myth, as any of us who have studied race know, is actually a deeply damaging stereotype. It is profoundly concerning in a number of ways. It increases high levels of pressure. It doesn't individualize between different Asian Americans. It erases structural factors like the level of education of immigrant parents and of long-term conditions of assimilation. Many, many, many things that we could go on and on about. But here is what's interesting about the Harvard case. On one hand, in the Harvard case, the argument was that the model minority myth was being used as a negative stereotype against Asian applicants. The argument went like this. Asian American applicants score higher on tests and often have higher GPAs than other students, particularly Black and brown students, who apply to Harvard. So they should have gotten in. But these students did not get in. So when we look for a reason why, what was found in the sort of transcripts of their interviews was that they were described as quiet, as unassuming, as shy. The argument was that Harvard admissions officers were applying these stereotypes about Asian Americans to these students and therefore were not admitting them because of this sort of version of the model minority stereotype. Now, here are some facts. When you actually, and this is where Ketanji Jackson comes from, she says you look at the record, and the lower courts looked at this repeatedly. If you look at white students' admissions files, if you look at Black students' admissions files, if you look at Latinx students' admissions files, many of them are all described as quiet and as shy and as diffident. And there is absolutely no difference in how frequently it affected them. And in fact, if you look at it really carefully, there's a positive correlation, not a negative correlation, between those descriptors and the admission of Asian American women. So contrary to it being something that kept people out, it actually, for Asian Americans out, it actually didn't function that way at all, and it was not exclusive to them. Second, the very notion that students get in with these 100 categories at Harvard simply based on test scores and grades was a massive misreading of the holistic admissions process, picking two factors out and using these as the most valued factors that should be determining a student's likelihood to be admitted. So what we know here is something else was happening in this ignoring of facts. And what I would say is, in fact, the model minority myth was being applied, right? That when all the facts said, wait, this isn't what's happening, the data doesn't show that Asian American students are being discriminated against. It doesn't show that they should have gotten in. Test scores and GPA is not the full determinant. There's no evidence they were discriminated against in any other way. But the premise kept saying, but these students should have gotten in. They should have gotten in instead of these Black and Latina students. And when you push the question of why, that's where we actually see the model minority myth raising its head. The premise was they should have gotten in because they deserved to get in. They must deserve to get in more. They should have been more deserving. They were hardworking. You see it all over the place. If you spend time in social media, where I do doing this work, this is the premise. Well, they studied harder, they worked harder, they should have gotten in. There's no evidence of this. What we actually see is a playing out of the model minority myth in the decision itself that ignores all facts, requires no proof of discrimination, and instead operates on impact and presumption. These Asian American students didn't get in. They should have gotten in because Asian American students are so qualified, and therefore they must have not gotten in because of somebody else. These Black and Latina students got in. Black and Latina students are not hardworking, are not deserving, and do not have the preconditions that should get them in. And so therefore, they must have gotten in unfairly and taken the spots from these Asian students. And I say this not because I'm trying to pit Asian Americans and Black and Latina students against each other, but because I'm trying to illuminate the extent to which both this case and how it was argued and the decision itself relies on stereotypes of lazy, undereducated Black and Latina children who come from schools and families with less interest in education, and pitting that against this poisonous notion of the model minority. And I call this poisonous not only because of its impact in this case, I call this poisonous because a great deal of research has shown that if you look at Asian American young folks who are politically active and civically engaged and largely progressive and interested in social justice, one of the first things that you see is that the turning point is this question of college admissions, and that there is a consistent, statistically relevant correlation between young Asian Americans who believe in the model minority myth and who espouse anti-Black racist beliefs about Black people's achievement and aptitude, and then who buy into the notion that affirmative action is racist or anti-Asian. So what we're seeing here is a profound replication of racism. So this is, I think, the implications for a broader racial political moment. What we're seeing here is a kind of divisiveness between communities of color that will not end, make no mistake, with this case. We're already seeing similar cases using Asian American plaintiffs happening on K through 12 level. We're already seeing similar cases around scholarship programs. This is a wedge issue that is going to continue to be perpetuated in ways that I think are extraordinarily dangerous. That said, I think I want to talk about sort of the strategies, the drawbacks, and who gets left out here. So obviously what we know is that the argument when this happened was, this is great, it's fine, two things. Either it's great, it's fine, finally we can turn to the real issue, which is class. So make no mistake, the questions of class in college admissions are profound. Issues of legacies, issues of donors' children are not issues that can be ignored and that interestingly are finally being looked at. That said, there are years and years and piles of data that show that there is absolutely no version of race-blind, class-based admissions criteria that seek to increase the representation of students who are first generation or low income that ever manages to actually lead to anything close to societally proportionate levels of racial diversity. It just doesn't work. Race and class are not synonymous. And it is simply not the case that universities and colleges have systemically banned the presence of poor white people for hundreds and hundreds of years. It is a very different history. So, who else gets left out? Interestingly, with the end of affirmative action, the 20% of Asian Americans who are Southeast Asian, Pinay, Pinoy, who actually were benefiting from affirmative action, who often are newer immigrant, come from newer immigrant families, lower socioeconomic levels, are actually completely left out in this decision. They are, encompassed into this particular model minority myth in ways that are going to be deeply damaging in terms of who you see. So that said, I think that's who gets left out. I want to talk about sort of that said, all of this said, where do we go from here? And I want to first talk about the fears. And I think that Professor Epperson laid those fears out really profoundly. And the greatest fear, of course, and I went through this in California, is that people read the decision not for what it says, but for what it might lead to. That they look so far down the road at the case that might happen that they become so risk averse to getting sued or to having to get their policies tested that things start getting taken off the table before we even get to them. It was a joke in California when you were doing diversity work that you could basically suggest anything and people would say, it was Proposition 209 is what was the ballot that overturned affirmative action in California. And people would say, we can't because of 209. And you'd say, but show me where in 209 it says that we can't do a bridge program. Show me where in 209 it says we can't do student-to-student recruitment. Show me where in 209 it says and they would just say 209, 209. So I think, and it's very real, universities have to think about how they manage resources and risk. But the ways in which something like SFFA can function to produce this chilling effect is profound, and it is extraordinarily dangerous. And that's why I think it becomes really important for us to emphasize precisely those aspects that Professor Epperson mentioned. One, that universities can still follow their mission and that they must follow their mission. That the only Supreme Court justice who questioned the value of diversity for higher education was Clarence Thomas. And it was a minority opinion, right? It was not the opinion, it was not the majority opinion. Second, that there are still ways in which race can be taken into account. Roberts puts it very clearly, experience and impact. And third, that contrary to popular belief, it is still absolutely not only possible, but essential for colleges and universities to collect data about the race of their applicants. And I mention this third one because we had a lot of students in California who stopped wanting to check the box because they somehow thought maybe they're so scared that they'll stop admitting students of color and they'll turn against us. At the same time as it's necessary to support this constitutional shift, right, this legal shift in jurisprudence, it is also necessary for schools and for the courts to enforce all aspects of the Constitution, which includes other forms of discrimination, like protecting against other forms of discrimination. That means that in order to be able to make sure that that is not happening, we have to be able to collect racial data. So what I say to students of color right now is this is not the moment to stop checking the box, and this is not the moment to stop applying. This is the moment instead to make sure that you think strategically about what you can do. Now, I want to point to the problem of this experience and impact approach, because it's easy to say, what's this great loophole? But from the perspective of a race scholar, it's also profoundly, profoundly problematic. And here's why. It might work. It probably will work, but it's highly problematic. So my joke about it is that we have now replaced the notion of diversity with the valorization of adversity. In other words, and we've seen this play out in every state that's had to make this swap, we are now asking students of color, in order to be admitted, to perform this kind of narrative of uplift and bootstrapping, of oppression and overcoming, of victimization and loss and trauma, in order to be seen as a valuable contributor with a seat at the table. We do not ask other people to do that. The notion that the only way that your race has a relationship to your college admission status is if you can show that it has somehow impacted your life, and Roberts even says this, in some way that you've had to overcome, is a deeply problematic notion. So, this said, right, and this is from This said, I think one of the things that we need to be able to think about is how do we keep the only way in which students of color gain admission to institutions of higher education as being through this kind of performance of adversity. And that, I think, happens through precisely the kinds of strategic programs that we're talking about. And one of the things that I really think colleges and universities have been very good about in the last few years is thinking creatively and broadly. And one of the places that that starts is absolutely recruitment programs. Groups of students who can be brought in together, cohorts, work very well. You know, they used to call them posse programs. They are a little bit outdated now, but they actually do still work. We know that actually one of the biggest issues is not simply recruiting students, but in fact, retaining them. Because one of the things that we know happens when admissions numbers go down is that we lose critical mass. And I think for anyone who has not been a deeply, deeply underrepresented, minoritized person in any space, whatever space it is, I think it is hard for you to fully estimate how hostile and alienating that environment can be. The less black and brown schools get, the harder it is for them to recruit black and brown students. We always presume that the problem is getting students in. But what we've seen in California is that is not the problem. The problem is not just getting them in, but getting them to come. Now, that will be a less severe problem now because they used to go to private schools, and now they can't. It's not any different. So, you know, I think I'd love to talk more about strategies. I do know that I ranted a little bit here, but I do think that this is a moment where it's easy to want to move on so quickly from the decision itself to trying to solve the problems that we can miss the fact that this is not simply a decision about college admissions, though it is primarily that. It is a red flag about a particular shift in racial political formations that we all have to be extraordinarily wary of.
Thank you, thank you. So I want to give the audience the opportunity to ask questions. And so I'm going to ask the first one while you think about it, and we got a couple of people here. But let me ask Professor Epperson. So we've been foreshadowing that there are more battles to come, and we've already seen lawsuits filed, as you both alluded to. You know, one example is a lawsuit filed in connection with the Freedom Fund. This is a fund that provides funding to black women entrepreneurs. Black women receive less than 1% of all venture capital funding. And this is a fund that gives actually relatively modest grants. I think they're $20,000 to black women entrepreneurs. And there's been a lawsuit filed there under a civil rights statute to attack that. We've seen attacks on the political side against DEI programs in state universities, and law firms being sued because they have diversity fellowship programs to try to increase the number of associates of color at their law firm. So what is the prognosis for what is to come, and what can those who are interested in being part of the effort to stave off the expansion of the principle that many people perceive to derive from the SFFA cases, what can they do now to help in that effort?
That's a great question, and I think that you mentioned there are these lawsuits already popping up, and I think one piece of it is understanding that there, as Sarah was saying, has been a sort of long-standing, well-organized campaign to eliminate any consideration of race in several domains, and really any acknowledgement of the history of the impact of racial discrimination in our policies, our practices, our laws in the United States. So the idea, on the one hand, that the Supreme Court decision in the Harvard and UNC cases is narrow in that it is limited to college and university admissions processes that take account of race is true. That is what the legal holding is. I did not mean to suggest that the buck stops there and nobody was going to be sued for anything after that, because the movement that sort of articulated this case against admissions will continue. And so, as Sarah mentioned, it's 10 years ago, Shelby County versus Holder, gutted the Voting Rights Act of 1965, and now here we are with two cases that are looking at Title VI and the 14th Amendment. So there is another frontier. There are going to be these cases in which there are challenges to all of the things that we talked about. I mean, that's going to happen. There are likely going to be challenges around recruitment, retention, partnerships, pipelines, scholarships. The reality is, again, when I said I think it's important to lead with the facts and not fear, it's to say, what do we know to be true about, for instance, Title VI of the 1964 Civil Rights Act? I mean, it was created in the wake of Brown versus Board of Education because we had a country that engaged in a form of apartheid. And that 10 years after Brown, 98% of black school children in Southern public schools were still being educated in entirely racially segregated schoolrooms. And so the 64 Civil Rights Act was designed and developed to actually root out these intractable vestiges of a history of racial segregation. And we do still have these requirements, if you will, that are a part of our Constitution, that are a part of federal law, to ensure that we root out this history, and that colleges and universities are doing whatever they can do pursuant to their missions to root out those pieces that are, those pieces of systems that have been, for better or worse, what we might call proxies for privilege that have existed for years. And so part of what happens after this decision is to go back and look at what are we doing that might be perpetuating these systems of inequity. And that's where you see, for instance, the challenge to Harvard's legacy policy, where so many colleges and universities do put a thumb on the scale for those applicants who have a family member who is a graduate of the school, or for a major donor, or looking at the role that standardized testing has taken, and what is the history of who gets access to those super expensive courses that help you figure out how you can do really well in the SAT or going to law school really well in the LSAT, and really unpacking what these things mean. It also means that for programs that are designed around programs that are about DEI, that are designed broadly around access and opportunity, that are created by private entities. Again, these cases are not about what private entities do in the space outside of education and admissions. The 14th Amendment is only about state actors, so that's why I said UNC, University of California, University of Michigan. These are, arms agents of the state, if you will. So public actors. Those private individuals, they are looking at those who take federal funding in some way. So most colleges and universities, even if they're private, have students that are, federal financial aid recipients, and that's where Title VI gets, that's where you kind of, it lights up, if you will, not for something that is fully private. So I also want to make that distinction, because when we're talking about who is vulnerable or what can someone do or not do, when you're talking about a private law firm that has a pipeline program, that's in no way implicated by the Supreme Court's decision about whether the use of race in an admissions process for a university that receives federal funding violates Title VI of the Civil Rights Act.
Thank you, thank you. I see a couple questions. I'll start here. Yep.
Yeah, my name is Jeremy Lowe. I think one of the biggest eyebrow raisers of the decision was the exclusion of the service academies. Sorry, I just lurched into that.
It's okay.
My name is Jeremy Lowe, and I think one of the biggest eye raisers from the decision was the exclusion of the service academies, and that the argument was diversity is good for the military. But couldn't you make that same extension to other service fields, like our teaching corps, nurses and doctors and so forth? And can't an argument be made that if this is good for that aspect of service, can't it be extended to other aspects of service? And I know there's already lawsuits that are coming for the service academy, so it just makes it incredibly difficult to know how to proceed.
Yeah, it's a great question. And so part of the reason there was for those of you who are wondering about the military academy part of this, the Supreme Court decision had a little carve out, if you will, a little footnote that they said nothing in this opinion is really related to the military academy. So not to the, West Point, Naval Academy, et cetera. that came about because of a history of 40 years of precedent in which the Supreme Court actually said diversity satisfies this really high level of scrutiny. It is a compelling government interest. And we think that one of the ways you can document this is that really having a diverse student body is actually a matter of national security, because you will diversify that officer corps. And that is important to have a sort of cohesive and well-run military. And this came about, this is back when I was in the litigation of this, and also doing, sort of helping colleges and universities with this. But, there was an amicus brief that was signed by, how many former Joint Chiefs of Staff, and talking about the importance of a diverse military. So that had been something that O'Connor wrote in her opinion in Grutter 20 years ago. She sort of lifted that from the amici, from that argument. And interestingly, in these cases, the Solicitor General, in oral argument, and we talked about this, made quite a case about how important, how we have seen why this is so crucial and critical. And so I believe that the intent of that was to say, this is why it's so important. This is but one example, but as you say, Jeremy, an example that you could use in many other domains about why this is so important. And instead of engaging with that, the majority opinion just put it in a footnote and said, okay, we hear you talking about military, but we're going to leave that alone. So it was a bit counterintuitive, and also went against the 45 years of precedent that actually said this was so very important. And so, as you said, now the entity that challenged the admissions policies at Harvard and UNC is now challenging the admissions policies for the military academies. So it is a bit, in that sense, it does defy logic, because what you are articulating is the logic of the court over the last 45 years.
Great. So, yes, got a question here.
Good afternoon, Ebenezer Jesse. Just a quick question regarding, actually, I think both of you can answer this. Chief Justice Roberts' language regarding nothing in this opinion should be construed to keep applicants from talking about how they overcome race. I guess I'm wondering two things. One, I guess when I read that, it sort of struck me as perhaps he's trying to fill in the blank for the fact that both in Grutter and in Fisher, the court has been sort of vague about what exactly the educational benefits are that flow from diversity. The court just had, and that was the holding, and that's what we proceeded under, but wasn't actually as specific and granular. So in some ways, he's just trying to sort of leave that pathway open. Is one way to view that. And then the other, for Professor Kaplan specifically, you made the point that no other group is asked to sort of essentially explain yourself in terms of diversity. But I guess I'm wondering, isn't it possible that part of the reason is because no other groups perceives their race as an advantage in admissions to highly selective colleges, and so there's sort of a double edge there. So just some thoughts that were going through my mind as you were both speaking. So thank you.
Except historically, for those who are not people of color, it absolutely unequivocally has been an advantage for access to higher education. That's the history that's, unquestioned. Sorry.
Yeah, no, absolutely. So since you started there, I will go there too. So I think, that is part of it, right? Is that we realize that this notion that race provides an advantage to students of color in higher education admissions is, again, another massive misconception. So first, if it really provided an advantage, then we would see students of color being admitted at rates that at a minimum were disproportionate to their admissions rate, which they're not. They're not admitted at a disproportionately high level. They're also not admitted at a level they're not present at a level that is disproportionate with No, they are present at a level that is disproportionate with their presence in the national population, but not in a good way. In a negative way, they are still underrepresented. And when we do work that we take affirmative action out of it, and we do things like, say, have law professors evaluate material from students who are coded by name to be students of color, and evaluate their fittingness for law school, in the absence of thinking about actual admissions or affirmative action, they are the same materials with a seemingly white name and a seemingly racialized name. The racialized materials are seen as less qualified and less prepared. So in fact, I think this is what we don't understand about race-conscious admissions, and this actually leads into the compelling interest question, is that race-conscious admissions was never intended to be something that gave students of color and applicants of color an extra advantage. It was intended, in fact, if you look at the origins of it in the 1960s and 70s under Johnson and Kennedy, it was intended to help to remedy what was already evident to be an ongoing thumb on the scale against them because of implicit bias and ongoing systemic racism, less well-funded schools, less access to advanced courses, less advanced tax base, less history of higher education, a history of testing that shows that what we think of as aptitude and IQ actually measures socioeconomic status, racial background, and culture. Right? So, in fact, there is no part of this was ever intended to be anything but an attempt to even the scales a little bit, which is honestly the best that it ever did. Now, that said, this speaks to the compelling interest problem. When affirmative action was originally created, the interest of it was put forth as not only, in fact, there was no question in it that said the reason we need to have this is because diversity is good for education, because it turns out better citizens and gives us a better workforce, and students learn better with students from different backgrounds. That was never the premise. The premise of affirmative action was two compelling interests. One, to remedy long-standing histories of discrimination and exclusion, that history that Professor Epperson laid out. And two, to ameliorate what was obviously ongoing implicit forms of de facto, right? Not legal, but in fact, discrimination in hiring and admissions and a whole bunch of things. But what happened is in the early cases, I think, was it
Yeah, in Justice Powell's controlling opinion in Bakke in 1978, they lay out four, what'd you say? I know. They lay out, I'm like, we just do like a little back and forth. They lay out, a series of interests that the university deems to be, compelling and important. And what Powell does is sort of strike down each of them, and we're left with diversity and what we would call the remedial justification. One of them had been to correct a history of societal discrimination, which we know exists, but Powell said was too amorphous. So again, we're getting to this idea where what are the things the court says is too squishy to measure. But Powell talked about the educational benefits that flow from having a diverse student body and said that this could be true for a number of factors. So he lists race, but he says that's also true of, the student from Iowa, where we don't have, many people coming from there, or somebody who plays the oboe, or somebody who lived on a farm. So he's outlining all different kinds of diversity. But again, this gets to my earlier point, the only one that receives that high level of scrutiny from the court is race. So in theory, then, a college or university has an admissions policy. They're looking at all of those things. At the University of Michigan, you got a big thumb in the scale if you came from the Upper Peninsula of Michigan, where not many black people live. But that was or first in your family to go to college, or wealth as a if you don't have it. In other words, we want more people. We want to open those doors of opportunity. But none of those are being considered or scrutinized by the court in this way. So I think that is the distinction. And the diversity rationale becomes one that, quite frankly, may be more palatable. It's saying this is great for everyone because it's not just about race. There are all kinds of forms of diversity. The remedial justification, which is pretty clear, unequivocal, and you can look back to history and law to see the very clearly documented history of discrimination, is not palatable, because those were the cases that we were making. Because the university, you have to essentially say, hi, we only educated enslavers. This is what we did to systematically exclude people of color over the last, hundreds of years. And most universities don't want to be in that position. And so the diversity rationale is an easier one for them to put forward.
And yeah, absolutely. And I think the last thing, and then I promise, Roger, I'll stop talking. The last thing I think that's worth saying here is, and this is, I meant to say this earlier. So one of the other problems with this sort of, adversity instead of diversity approach is that it does something really interesting in terms of where it lays the responsibility. So it continues this sort of idea that students of color, like I said, have to perform at, their overcoming of adversity and their sort of trauma and their exceptionalness. But also, beyond that, what it also does, and this is something actually that Ketanji Brown Jackson points out brilliantly in her opinion, it swaps out any capacity to address systemic, structural, and population-wide oppression or discrimination for an individual case. So there's nowhere in there where you can talk about what it means to come from, you know, you can't, there's nowhere in here where students, black students or students of color, can talk about histories or ongoing practices of residential segregation and how that just affects how much access they're going to have to the AP and honors classes that are going to give them a 4.5 GPA. There's nowhere in there to talk about questions of generations of inherited wealth that make possible all kinds of educational and academic benefits, multi-generational access to higher education that are disproportionately available to white people. Not all white people, but disproportionately unavailable to Black and Latino folks and disproportionately available to white folks. Those kinds of structural levels of discrimination, systemic discrimination that affect one's capacity to put forth a colorblind grade A gold star application to a top school, there's no place for that in your essay about adversity.
Well, I promised you a thought-provoking discussion. I think I delivered, or I should say they delivered. And I want to thank Professor Epperson and Professor Kaplan for such an engaging discussion of these critically important issues. And we are in uncertain times. That is clear. But I believe that this institution, American University, is fully committed and remains fully committed to pursuing diversity and achieving diversity in its student body and promoting inclusive excellence, as we often discuss throughout our university community. We often said that our students, and I see many of them here in the audience, are change makers for a changing world. And I believe that it is imperative that we remain committed to training leaders from all segments of society to help us navigate our increasingly complex collective future. Thank you for being here, and have a wonderful rest of your day. Thanks so much.
Thank you all. Thank you.